Good evening, ladies and gentlemen, and welcome to tonight's Quadrant Chambers Spring Shipping Seminar. My talk this evening is going to be on the interclub agreement and whether it's doing its job or whether it's too crude and mechanical. And I want to consider two cases which have been handed down in the last 12 months or so, which deal with the interclub agreement. Quick recap on the interclub agreement. We all know about it. The historical background is pretty clear. First came in 1970, amended in 1984, but the current version we've had for a very long time, since 1996, which begs the question, why do people go back to the 1984 form to try to construe the 1996 form? That's something I'll come back to in both of the cases I'm about to consider. The purpose of it was explained in the BIMCO circular, a mechanical approach to the apportionment of liability, as it says here, which has been so successful in avoiding protracted and costly litigation. I'm not sure that's right, as anybody here in this room will probably know from LMA arbitrations where one picks over the causes and claims under the interclub agreement or in the litigation which has just ensued. The broad scheme is mechanistic and crude because it simply looks at causes. If it's anything to do with the seaworthiness of the vessel or the navigation or management of the vessel, then it's 100% down to the owners. If it's anything to do with cargo handling operations, say in one particular case, where the charter party reads in a particular way, then it's down to the charterers, and then any other claims are divided up 50-50, save in special circumstances. The two cases which are usually trotted out in this context, and are trotted out in both the cases I'm about to consider, are the Strath-Newton, where Lord Justice Carr said it's a mechanical apportionment of financial liability, independent of standards of obligation in the contract, and the Ben Laws, where Mr. Justice Hobhouse compared it effectively to a knock-for-knock position under motor insurance and under offshore contract forms, not concerned with considerations such as moral culpability. So the first case I want to consider is the decision of the Court of Appeal in Transgrain and Yangtze navigation, and this is the ship, the Yangtze Jinhua, and the facts were pretty straightforward, but let's consider first of all the particular provision in the interclub agreement with which the case was concerned. Clause 8D, the Cinderella, if you like, of the interclub agreement, because it's the one that is the sweep up at the end. All other cargo claims whatsoever will be split 50-50 unless there is clear and irrefutable evidence that the claim arose out of the act or neglect of one or other party. So intended really to be a mop-up, because it will never cover areas which are covered by 8A, seaworthiness, navigation and management, 8B, cargo handling operations, which are down to the charterer. And therefore it will only apply if you're outside those two very common situations, and it will only apply if you have a very clear case, clear and irrefutable evidence, that the claim arose out of the act or neglect of one or other party. And that seems pretty straightforward, I think. Take the facts of the Yangtze Jinhua claim for damage to soybeans shipped from South America to Iran. Order given by the charterers when the ship arrived at Iran for the ship to wait for 4 months to allow cargo receiver operations to be sorted out and the contract of sale to be finalised. The relevant finding of fact was the cargo was absolutely fine, got to Iran without any difficulty, but simply couldn't withstand the extra 4 months. As Lord Justice Longmore put it, cargo was too moist to withstand the prolonged delay, or put another way, the delay was too prolonged given the moisture content. So the owner said, well, the only reason I've got this cargo claim against me was because of your act asking the vessel to wait for 4 months. Therefore, it's not a 50-50 split, it's a 100% split. And the charterer said, no, act doesn't mean any act, it means a culpable act. And all I gave you were access to employment under a time charter. That can't be culpable. The approach of the court was to take a pretty dictionary approach to what act means. And the Court of Appeal held that act means act and does not mean culpable act or fault. So Lord Justice Longmore said that Mr. Justice Tier and the arbitrators were right in giving act its natural meaning. No need to confine it to culpable act. And Lord Justice Hamblin said the natural meaning of the word act is something which is done, it does not connote culpability. And that fits in with the scheme of the ICA, which doesn't look at culpability at all, but simply looks at broad, factual causes. And that was emphasised by Lord Justice Hamblin, who said that the critical factual question under Clause 8 is nothing to do with culpability or blame or breach, but simply looking at causation. Does the claim in fact arise out of the act, operation or state of affairs described? The Court of Appeal optimistically said that this does not result in uncertain and difficult questions of causation, and again, possibly optimistically, said it doesn't lead to unacceptably wide liability because causation is an important limiting factor, as is the need for clear and irrefutable evidence. And I don't know what those of you in the room thought about this case, but I thought it was a pretty straightforward application of Clause 8D, some pretty straightforward facts. Strangely, there's been quite a lot of comment about it, and saying that it raises very, very difficult causation questions. I don't know whether any of you remember this game, the mousetrap game, where if you turned the lever at A, by a long chain of circumstances, the mouse would be caught at O. And the reason I put that slide up is because of the strenuous argument in the Court of Appeal, but also echoed in some intersolicitor bulletins and news releases, that this is a very, very worrying decision and poses an open door for causation and an open door for charterers' liability, because, it said, the result of the owner's argument means that any act will do, and therefore it will extend to a simple act of a charterer who gives the order to ship a cargo which is susceptible to moisture damage. Why has the moisture damage come about? Well, because you ordered me to load it, therefore it's your act, therefore it's 100% charterers, not 50-50. The Court of Appeal found that submission, and I think rightly, very difficult to follow, and what Lord Justice Longmore said was that the suggestion that an order given by charterers to load a particular cargo at a particular port would constitute an act with no further inquiry being necessary could not be right, because that set, like the mousetrap game, an impossibly long chain of causes and looking into causes of causes. So I want to suggest that the worries about the Yangtze Xinhua, I'll get that right in a moment, are unfounded, and therefore there isn't, as it were, perpetual circle of the charterer giving an order to load a cargo in an inherent vice case and being automatically liable under the ICA for 100% liability. Take three different situations. Shipment of cargo, which has got nothing wrong with it, except that it's a cargo that's susceptible to inherent vice, nothing particular in the carriage, and it goes wrong. No one's act is actually responsible for that cargo damage, so it's a classic 50-50 split. Take another case, a case I'm concerned with at the moment, where the cargo is shipped in excess of particular loading regulations, which say moisture content 10%, nothing above, and it's shipped at 12.5% or 13%, that makes cargo damage almost inevitable. Obviously, an act of the charterer in shipping it, 100% charterers. Take another case where the cargo is susceptible to moisture damage, but in some way the ship doesn't look after it on the voyage, closes its ventilators, opens its ventilators, and the cargo goes off because of that, 100% for the owners. So that's the first case I wanted to discuss. Second case I wanted to discuss was the Agile Holdings and SR Shipping case, where judgment has been handed down in the last 2 weeks. They're very topical. I was involved with Peter Stevenson for the successful appellants. That's not the only reason I'm citing this case. And I won't mention anybody else in Chambers who was involved for reasons which I will tell the people over a drink later. The facts were simple. DRI cargo being loaded in Tunisia to go to India. After loading had been underway for a while, there was a fire on the conveyor belt. The supercargo, who was the charterer's man, said after they put the fire out, said that's fine, keep on loading. And after the vessel set sail, the cargo overheated and was very, very badly damaged. A whole range of issues, interesting issues, came up in the award about what part of the interclub agreement it fell under, but the arbitrators held it fell under Clause 8B, loading, stowing, or other cargo handling, and therefore ostensibly 100% for charterers. But this was a Clause 8B case where the argument ran that it's a 50-50 case because of the way in which the charter party was worded. And you'll remember Clause 8B, claims arising out of loading, stowage, lashing, etc., unless the words and responsibility are added in Clause 8, we all know about that, or, and this is the bit that the case concerned, there is a similar amendment, ask yourself what similar means, similar to what, making the master responsible for cargo handling, ask yourself what responsible means and what does it mean by the word cargo handling in which case 50-50. So those are the questions. What's involved in that sort of amendment, and what does similar mean? I think the starting point in considering Clause 8b is the ping-pong game that goes on under the NYPE Clause 8 in relation to allocation of cargo responsibility. In looking for a picture to illustrate the ping-pong game, I came up with also this picture, which apparently is the British equivalent of ping-pong. That was the one before is an American game. The British equivalent of ping-pong was whiff-waff, an idea which never caught on, unfortunately, but so whether it's whiff-waff or ping-pong, the NYP Clause 8 regime is this. At common law, all responsibility for cargo handling and matters going wrong with cargo handling is on the owner. Under Clause 8 of the NYPE, it shifted back to the Charterers, Court Line and Canadian Transport, and the unpopular decision in the IMBROS, which says that includes the Charterers being responsible for stowage and cargo handling matters that affect the seaworthiness of the vessel unless the master intervenes. Ball's gone back on that side of the net, hit it back again. If and responsibility is added, it comes back to the owners completely. In the Maria, the case we're considering, there was an unamended Clause 8, as you can see. But there was a strange rider clause, Clause 49, which said that the stevedores were to remain under the direction of the master, who would be responsible for proper stowage, only stowage, and seaworthiness and safety of the vessel. Now, what's that clause doing? Is it reversing the Court Line and Canadian Transport transfer of responsibility, or is it dealing with the IMVROS, the concept of it being unfair that the owner shouldn't be responsible for stowage and unsafety and seaworthiness matters? The arbitrators held that although Clause 49 made the owners responsible only for part of cargo handling, stowage only, that was insignificant and irrelevant. The reference to seaworthiness and safety was also not significant and was irrelevant, but the use of the word responsible was highly significant. It was a buzzword to take Charterers' submission, and therefore, although this had happened during stowage and not loading, it was to be treated as a similar amendment with a 50-50 split. First question, what does the concept of a similar amendment require? Does it have to be alike as two peas in a pod? And what does similar mean? And the Judge Waxman, sitting as a judge in the commercial court, didn't see any difficulty about the point at all. It's intended to connote a provision which is of the same kind or effect as the addition of the words and responsibility, and that distinguishes it from a provision which is the same as and responsibility. And that's because the amendment must be to effect the transferring of all cargo handling responsibilities back to the owner and not just some of them. So effectively, you're looking for a clause that has the same sort of effect as adding the words and responsibility transfers all responsibility for all cargo handling back. Therefore, if the clause does that, it works. If it doesn't, but only transfers part of it back, it doesn't work. Simple mechanistic approach. And the judge therefore rejected the argument by SR, the Charterers, that it was enough that it transferred part of responsibility for one particular operation, trimming, lashing, stowing, and not all of it. And the judge reached his decision on the basis that that was true to the language of the ICA and had the merit of simplicity and certainty which underpinned the ICA regime. Last question, the purpose and effect of Clause 49. Here's the vessel which I've been involved with. It was overturned in the port of Algeciras due to top-heavy cargo being loaded. Clause 49, as the judge said, dealt with stowage only, and it was inapposite to read that term as covering any other type of cargo operation, and therefore he held that Clause 49 was probably designed to reverse the effect of the IMBROS decision. Now, apparently, I wasn't aware of this, but in our Section 69 application, we said this clause was in common use. There are common variants of this sort of provision which try to transfer back to the master responsibility for stowage which affects the unsafety and unseaworthiness of the vessel, and the judge thought that was probably the right reading. So general conclusion as I come to an end, a robust approach in both cases. The purpose of a mechanistic and causation-based scheme has been endorsed by the court with a very straightforward interpretation of the language. As the judge said in Agile and SR, it is a very lightly worded regime and doesn't merit very much sophistication in terms of linguistic analysis. He found no guidance from any explanatory notes. Not surprising, there aren't any explanatory notes. And he also said that he wasn't helped by the previous texts. And I think that's important. I leave you with this picture. Archaeologists are not welcome. Here's a picture, metaphorically, of the council team in the Yangtze shipping case preparing their arguments on the 1996 form by unearthing the 1984 form. A lot of energy was expended in the Court of Appeal in saying, well, if you look at the textual differences between 1970 and 1984 and then 1984 and 1996, we must be right. The Court of Appeal were not impressed by that argument. Mr. Justice Tier said it was an impermissible exercise in the archaeology of the forms, which have been disapproved of by the court, for example, in relation to the Norwegian sail form in the Rua. And the Court of Appeal said, how can you compare the 1984 form and the 1996 form? Because they're completely different. So thank you very much indeed. That's what I have to say.
Well, the speaker number one satisfied the 15 minutes test. So now we're on to speaker number two, Poonam Malwani, who is a phenomenal advocate, it says, and always in demand.
Most times when counsel give talks at things like this, they choose to talk about a case that they've been involved in as a bit of self-promotion. If on the way here you were bored of deleting emails telling you about new privacy policies and decided instead to just Google in the law reports Malwani and LOIs, you'd have got a whopping result of 0. Never fear, I shall self-promote. In fact, the Zagora, where judgment was handed down by TRJ at the end of 2016, was my case and one of my greatest triumphs, because I managed to get judgment even though neither my solicitors nor I appeared in court. It was a typical letter of indemnity case with several LOIs given, from the bottom buyer to the seller, from the seller to the voyage charterer to the time charterer to owners at the top. Litigation ensued, which rumbled on for many years, and through which I was counsel for voyage charterers. A few weeks before the trial was due to start, the solicitors for the bottom buyer stopped engaging in correspondence, and a few days later came off the record. A few days later, things happened in my camp, and my solicitors, and therefore I, came off the record. However, the trial proceeded with the other parties. Oldendorf, who was above me in the chain, wanted a judgment on the merits for enforcement purposes. And so at trial, counsel for Oldendorf put to TRJ all the arguments that me and the person at the bottom had been running in the pleadings and the witness statements, so that there could be a judgment on the merits, admitted to TR that all these arguments run by me and the bottom were rubbish, and sought a judgment. TRJ agreed they were all rubbish and gave Oldendorf judgment against me, but because he was deciding everything on the merits, also gave judgment in my favour against the people on the bottom, which, as I say, I thought was a pretty good triumph. However, on to matters of substance. You all know what a letter of indemnity is, and actually loose with your pack should be the standard P&I Club wording of one. This picture on my slide highlights some of the usual features. There are, in fact, only a handful of authorities on LOIs, but what is clear is that the courts do strive to find that an LOI is responsive to the situation. The carrier at the top of the chain has given up his fail-safe procedure of waiting until an original bill of lading is presented to him for good commercial reasons that benefit everybody in the story. No one wants the vessel hanging around incurring demurrage or hire and doing nothing at the discharge port while a bill of lading has got delayed in the banking chain. In return for giving up the fail-safe process of an OBL, the carrier has agreed to take an LOI, and the courts have been astute to reject technical arguments that seek to defeat the owner's rights. So on this slide, which is a couple more on in your thing, some quotes of examples where the court has given a robust approach. One such example was given by Lord Clark in the Lamb Thong Glory. That was the Court of Appeal case, which decided for the first time that where an LOI is given by someone down the chain, addressed only to charterers, nonetheless, owners at the top, who are the carriers and the bill of lading issuers, owners at the top could sue under that LOI, even though they weren't a party to it, under the Third Party Rights Under Contracts Act. And you've got on these two slides, on page 3 of your booklet, the way in which the argument was advanced and then accepted by the Court of Appeal. But that's clear law now that that right exists under the Third Party Act. But along the way in that case, Stephen Berry, for the LOI issuer, advanced a sophisticated linguistic argument based on the different uses of the word you, Y-O-U, in the LOI, seeking to argue that the LOI wording could not indemnify losses sustained by the owners who, the LOI not being addressed to them, were not you. Lord Justice Clark, as he then was in the Court of Appeal, recognised that the point had, quotes, obvious force, but rejected it as wrong in the light of commercial common sense and found that there was liability under the LOI. The Zagora, the Jagravi, which we'll come to discuss, and the Songa Winds, which was decided earlier this year, are all cases where LOI issuers sought to argue that they had no liability under the LOIs by relying on factual matrix, emails sent by the various parties while the LOIs were being issued, collateral contracts were pleaded, estoppels, rectification, but they were all rejected with no difficulty. Because going back to one of the original slides, and as His Honour Judge Mackey said in the Jagravi, the approach of the courts is that LOIs are important commercial documents to be interpreted robustly and in a straightforward way without faffing around with side emails and collateral contracts. Further examples of the robust approach to indemnification appear in in all the cases decided on LOIs. The LOI on its wording requires the LOI issuer to provide security in order to avoid an arrest of the vessel or to release the vessel from arrest. In the Bremen Max, the owners arranged for security to be put up and the vessel was already released. They nonetheless sought an injunction forcing the LOI issuer to put up replacement security. The simple argument of the LOI issuer was no, the wording of the LOI is to provide the original security to release, to avoid arrest or release. That's already happened. So we've got no obligation to provide replacement security. TRJ was having none of that, said it would defeat the commercial purpose of the LOI and ordered replacement security to be provided. Similarly, the Court of Appeal in Jagravi dismissed the argument that there has to be complete delivery of the entire cargo before the indemnity can bite. Lord Justice Tomlinson in the Court of Appeal said obiter that there could be part delivery and indemnification in respect of that delivery because otherwise there could be lack of efficacy in the LOI. But against that background, there are still two crucial areas where the standard form is blank and where the parties you're advising could sort themselves out properly in advance. The first big blank in the standard form, if you look at it, is to whom the LOI is addressed. In brackets, it says to owners. In reality, it's far more commonplace in practice for each person in the chain to issue and address their LOI to the person directly above them in the contractual chain, to their contractual counterparty. But where you've got a chain of LOIs like that, you're going to be left holding the financial baby if the person below you is insolvent. So particularly as owners, but also it seems to me as intermediate parties in this chain, it makes sense for you to seek to be the beneficiary of as many LOIs below you in the chain, to have them addressed to you as you can, But note, making sure also that you are sent, or at least know the contents and nature of the addressees of the LOIs. That an LOI can be addressed to more than one party, take effect as an offer and then a contract with multiple parties, is clear from the JAG-RAVI. In that case, the LOI was addressed as quoted there to owners/disponent owners/charterers. That was from a buyer down the chain, and he gave it to charterers, but that's how it was addressed. The Court of Appeal rejected the argument that this was a single composite offeree or a compendious way of describing just one person, instead accepting that actually it was addressed to all those different people in a descending hierarchy, owners, time charterers, voyage charterers. So you can have an LOI addressed to more than one party, giving rise to each of those parties having a direct right against the LOI issuer. So in this case, the JAG-RAVI, owners at the top wanted to rely on this LOI because the intermediate charterer was insolvent. The problem was that although it had been addressed to them in this way, owners hadn't known about it. Their charterers hadn't actually sent them a copy of it. They only found out about it during disclosure after delivery in contested proceedings in India. The view of Mackie J. In the JAG-RAVI at first instance was that in those circumstances, owners could not rely on the LOI. An LOI, he held, is a unilateral contract, like in the reward cases. So if you don't know about the offer, but do what happens to have been asked for in return for the reward, and you do it, but you don't know about the offer of the reward, then you can't claim the reward. It's one of the basic offer and acceptance principles of English law. And on this slide, I've given you the arguments that were run, and including where Chitty says, well, can't see what legitimate interest is being prejudiced if you did allow enforcement in these circumstances. But nonetheless, even counsel arguing the point in JAG-RAVI had to concede that the weight of the argument was against him, and that was what Mackie agreed with Obiter. In fact, it wasn't argued in the Court of Appeal at all. So, if you don't know that it's addressed to you, assume you're not going to be able to rely on it. So the practical point is to get LOIs down the chain addressed to you, as many as you can, and make sure you know it and get a copy of it before delivery, thereby increasing your rights of finding a solvent person to sue when litigation ensues. Now, of course, as per the Lamthorne Glory, as I touched on earlier, owners can sue under an LOI, even if it's not addressed to them, under the Third Party Act. And per the Court of Appeal in the JAG-RAVI, owners can sue under the Third Party Act, even if the LOI is addressed to them. And that was the oddity in the JAG-RAVI. There, because owners didn't know about the LOI before delivery and the unilateral contract rules, they couldn't sue in it as a direct contract. Mr. Rainey's pushing at me. Have I come to time? Okay, I'm going to speed up. Thank you for that, Simon. Couldn't sue on the direct contract because they didn't know about it, but could sue under the Third Party Act. I find that somewhat counterintuitive, actually, and I could think of arguments to the contrary, but for the moment, that's binding Court of Appeal ratio. However, rights under the Third Party Act are not perfect. Under that act, any defences which the LOI issuer could use against the contractual person, the charterer, can be used as a defence against owners. So in the JAG-RAVI, the issuer said that charterers knew that the delivery was wrongful and contrary to public policy, so that even owners didn't know that. Nonetheless, that was a defence to owners' claim under the Third Party Act. That argument failed on the facts, but would arise and leaves owners or whoever's trying to sue under the Act susceptible to defences available against others, not to them. Hence, it is still a valid and important right to try and get the direct contractual right under the LOIs addressed and given to you in advance. Next, in about 2 minutes, is the question of to whom delivery should be made. In the old LOI standard form, it was provided if you deliver to X, then I will indemnify you. Now, as you'll see in the sheet, which is underlined, in response to the Bremen Max and TRJ raising questions about estoppel, the LOI form has been amended so that there's a new delivery proviso that the indemnity bites as long as delivery is to someone owners believe to be X. What that means, importantly, as TRJ said in the Bremen Max, is you need to engage in correspondence with the people issuing the LOIs to get them to actually identify which entity is coming on board. All too often, it's not one of the commercial parties, it's the port agent. And so the port agent comes on. Why do you think the port agent represents X? So what you need to do is engage in correspondence to say who's coming, so that you can say, well, they told me X was coming, and therefore I was entitled to reasonably believe that X was representing the person that the LOI referred to. I'm going to stop there because I think I've reached my...
Thank you very much.
I will say this though, if you do both those things, make sure you have the LOIs and make sure you address to you and engage in correspondence about the person, then there will be even fewer LOI litigated cases for us to discuss.
Thank you very much. Now we come to Robert Thomas.
Good evening, everyone. I'm actually going to lower the tone a bit and talk about rotten bananas. This is, or more accurately, was the Baltic Strait. She's a reefer vessel, and by the time of the events in question, she was 33 years old. And surprisingly, her reefer equipment was, to put it charitably, in need of some TLC. And we put a couple of photos up just to show the state. That's entirely homemade trunking that was spotted on the vessel, good degree of rust, and a liberal use of duct tape to keep things together. In any event, more relevant, she was voyage chartered by Comico to carry a consignment of bananas, which they had purchased from various producers in Ecuador and wished to ship from Guayaquil to the Mediterranean. The charter provided for a range of discharge ports, and Tripoli was eventually chosen once the cargo had been sold to the claimants, Al Fadul. Now, importantly for tonight's purposes, Al Fadul also became the lawful holders of the bills of lading relating to the cargo, and therefore they assumed the usual rights of suit under the 1992 Act. Now, when the vessel eventually reached Tripoli, after what was not an unusually long voyage, the cargo was found to be in less than an ideal condition. There you can see some of the damage that was found. Apparently, it was just a little bit past its sell-by date. Now, unsurprisingly, having received cargo in that state, Al Fadul were not best impressed, and about 4 days into the discharge process, they purported to reject the cargo and claim a refund on the price. In due course, a deal was struck, as the tribunal found. Comico agreed to credit Al Fadul with a sum of money which was to be spread over 3 subsequent shipments. You'll note that the sum that was credited was less just 16 US cents, the same figure that had been paid in insurance insurance proceeds by the insurers SEAT. Now, despite the extreme similarity of those two sums, Shipowners' Council, who's here tonight, managed to persuade the arbitrators to find that the sum was not paid by way of insurance proceeds, but by way of settlement of the dispute between Al Fadul and Comico. And that finding was important for our purposes, because whereas insurance proceeds are classically raised inter alios acta, it allowed the ship owner to argue that the proceeds of the settlement should be taken into account so as to reduce the damages which Alfadul could claim under the Bill of Lading contract. Effectively, what they said was that Alfadul hadn't suffered that loss. It was Comico that had suffered that loss, and it was they alone who could claim in respect of it, and they would have to do so under the Charter Party and not under the Bills of Lading. Now, in response to that argument, we advanced three counter-arguments before the arbitrators. The first I've already touched upon was effectively a factual one, that the sums paid represented insurance proceeds and were therefore raised inter alias acta. Secondly, in any event, we argued that by virtue of Section 2.4 of the Carriage of Goods by Sea Act, which I'll show you in a moment, Alfadul was in any event entitled to claim all the sums in question, irrespective of who had actually suffered the loss. And the third limb of our argument was that as a matter of common law, Alfadul was entitled to recover the full amount of the loss, irrespective of any recovery from their sellers. Now, the tribunal disagreed with us on the first issue, as I've already mentioned. They found that there was a settlement and not a passing on of the proceeds. But they agreed with us on the second issue, i.e. they found that under Section 2.4 of the Carriage of Goods by Sea Act, which is on the screen, Alfadul could indeed claim all the losses, including those sums which ultimately fell to the account of charterers Comico. And just while we're there, 2 points to note. Firstly is the very wide wording of subsection A, so that it applies where a person with any interest or right in or in relation to the goods has sustained a loss. The other point to note is the requirement in the last part of the section, such that the rights can be exercised only to the same extent as they could have been exercised if they had been vested in the person for whose benefit they are exercised. In other words, the person who suffered the loss. Now, the tribunal's finding on that second issue meant they didn't need to consider the position of common law, which was our third argument. And indeed, they didn't even mention it in the award. In any event, as a result of their finding on the construction of the statute, they awarded Alfadul the full amount of the loss in an amount of $4.5 million. Now, having been soundly defeated before the tribunal, ship owners sought and were granted permission to appeal on two questions of law, which are on the screen at the moment. The first was quite a narrow one, and effectively they sought to argue that the section only operated where the rights of suit were previously vested in the party that had suffered the loss, but it had lost them by virtue of the operation of Section 2.1. The second was whether the lawful holders of the Bill of Lading can claim by virtue of Section 2.4 losses suffered by the charterers of the vessel in respect of the Bill of Lading voyage whose charter party was with the Bill of Lading carrier. So they put it in two ways, hoping to overturn the decision of the tribunal. Now, those issues came before Andrew Baker sitting in the commercial court, and at that stage we asked him to reconsider the position at common law as well. We said the tribunal were right on Section 2.4, but in addition, as at common law, they would in any event be entitled to claim the full amount of the damages, and so the answer would be the same. Now, the judge dealt with the issues in a different order to the one I've outlined them, but I'm going to deal with them in this order because it adds to the suspense. Now, in relation to issue 1, as I think I've already explained, the first argument that ship owners raised was effectively that for the section to apply, this is Section 2.4, the rights vested in the holder of the Bill of Lading must have previously been vested in the party suffering the loss, and those rights must have been transferred or lost by that party by virtue of Section 2.1 of the Act. Now, that argument was based on the three words you'll see highlighted on the screen, but, and so that. And the argument was that those were said to impose or indicate a causal link or requirement of the sort for which owners contended. Now, I have to say, I never really understood that argument, nor did the judge, and he found it wasn't made out either as a matter of language, or indeed more broadly given the consequences of the argument, because it would give section 2.4 a very narrow scope and would mean it wouldn't apply in many of the cases which the Law Commission and indeed many commentators considered were the most likely cases where it would be of use. So, in short, that first argument got very short shrift from Andrew Baker. The second issue, however, took more consideration. The ship owners refined the case they had advanced before the arbitrators and relied on the decision in the Dunelmia. Now, that's a decision of the Court of Appeal under the 1855 Bills of Lading Act, and it lies at the heart of what we commonly refer to now as the mere receipt rule. In other words, the bill in the hands of the charterer is usually a mere receipt. Now, actually, by the time of this judgment, there had been no case deciding whether the position was in fact the same under the 1992 Act. But the judge decided that given that the wording was almost materially identical, the position would be or is the same under the 1992 Act. He concluded the consequence of this was that whilst, as the statute expressly says, section 2.1 has the effect of transferring to or vesting the rights of suit under the bill in the charterer, that vesting or transfer does not entitle him to recover losses he may have suffered from the carrier through the exercise of those rights. So you have rights, but they're not worth anything. Crucially, he went on to identify the relevant question arising on the wording of section 2.4 as being to what extent the rights of suit vested in the holder could have been exercised by the loss sufferer if they had been vested in that person by section 2.1. I hope you're following. His view was that the inexorable logic of the Dunelmia decision was that if the loss sufferer was the charterer, the answer to the question was not at all. As he put it, the arbitrators asked themselves correctly whether, if we were to hypothesise that the charterers had vested in themselves the rights of suit under the Bill of Lading, would they have been entitled to recover the loss suffered? In the face of the limited argument presented to them, they answered yes. In my judgment, with the benefit of the argument developed on appeal, the correct answer was no, unless they were charterers to whom the mere receipt rule did not apply. So in other words, what he found was that section 2.4 cannot generally be used to recover charterers' losses. And certainly to that extent, it runs counter to one of the policy objectives of the Law Commission's reform, which was stated to be to prevent carriers being able to question the entitlement of the Bill of Lading holder to recover losses by raising technical points that the loss had ultimately been suffered by someone else. Now, in fairness to the judge, he did consider that particular criticism. He said that to resist a claim under the Bill of Lading on the basis that the carrier's liability in respect to the relevant loss was governed by a separate contract, i.e. the charter party, was not a technical point, and indeed his view would override the freedom of contract. What this does mean is that very careful consideration will need to be given in these sorts of cases as to whether separate arbitrations or claims are in fact required in order to avoid a partial or possibly no recovery at all. And that, in my view, at least is a dent, arguably a significant one, in the effectiveness of the Act and indeed its objectives. Now, whilst that part of the judgment will certainly be unwelcome to cargo insurers and cargo interests more generally, The judge's decision on the third issue certainly softens the blow. In relation to the common law position, the judge considered the decision in R&W Paul, which has been around for some 80 years. In that case, the plaintiff had sued the bill of lading carrier, alleging it had title under the bills of lading and under the old Act to a cargo of maize that had arrived damaged. They, in fact, had recovered compensation from their sellers in a separate arbitration, so a very similar situation to the one in the Baltic Strait. And in his judgment in that case, Goddard, Mr. Justice Goddard, as he then was, decided this didn't affect the position as between the holder of the bill and the carrier, but only the ultimate destination of the damages, which it was accepted would be held on trust. Now, in seeking to argue that this wasn't reflective of the modern law, the shipowners relied on the Sanix Ace, which many of you will be familiar with, to argue the doctrine of full recovery in respect of damaged cargo was limited to cases where the claimant owned or was entitled to immediate possession of the cargo when it was damaged. Now, in the Sanix Ace, ownership had mattered because it involved a voyage charterer claiming full damages under a voyage charter, although he was neither the receiver nor the end purchaser of the cargo, and had himself been paid in full because the risk in the cargo had moved to the ultimate purchasers before they got property. Now, Andrew Baker rejected that argument. He rejected the suggestion that the Sanix Ace confined the decision in R&W Paul, preferring instead to find that it extended the decision in R&W Paul, and that remained sound law, at least where the bill of lading holder receives cargo in the damaged condition from a ship, and they then own or later come to own the cargo pursuant to some appropriate sales arrangement. He went on to find what he described as a pleasing coherence or symmetry between the two cases, and you'll see on the screen how he summarised it. A situation where the carrier is liable in full for damages if sued by the receiver, who by reason of the carrier's breach received damaged goods rather than sound goods, the Paul decision, or if sued by a claimant who did not receive the damaged goods but owned them when they were damaged by the carrier's breach. Importantly, he found that in either case, it was the property in the goods that carries the right to recover full damages. So that part of the decision, I think, definitely is of a considerable comfort to cargo interests and cargo insurers. But the judge was very careful in his judgment to say he did not need to and did not decide how far the principle of R&W Paul might apply beyond the situation in front of him, where the bill of lading holder receives the cargo and then owns or later comes to own that cargo. So how far the principle may be applied is yet to be decided. In light of that, and given his finding in relation to the scope of section 2.4, it still seems to me to be necessary to give very careful consideration to the question of whether separate proceedings are required in order to ensure full recovery of losses in circumstances where there is even a risk that part of the loss may have been suffered by the charterer, seller, and...
Well, I think that probably brings your talk to an end.
And that is almost it. For your information, permission to appeal was refused, so the Baltic Strait decision certainly won't go any further at this stage. Thank you.
So now we turn to John Russell, who has two plaudits. Both of them say he's incredibly impressive.
Got to pay for a lot of money for those sort of comments. I'm going to break Poonam's rule, and I'm going to talk about a case in which I've had no involvement whatsoever. It's also because the case that I am going to talk about, which is the Phones for You and EE case, is an important case that really I think we all need to give some consideration to on any occasion where a contract is to be terminated and the innocent party has both a contractual right to terminate and also a common law right to terminate. So the factual situation I'm going to look at is a case where the bad guy is in repudiatory or renunciatory breach of contract or breach of condition. The innocent party or the good guy terminates, and the good guy suffers loss of bargain damages as a result. The question is, can the good guy lose his right to claim loss of bargain damages by reason of a careless termination notice? And in particular, can he lose the right to claim loss of bargain damages by referring to a contractual right to terminate in his termination notice? Now, until recently, one would have been forgiven for thinking that the law was reasonably settled and adopted a fairly liberal approach in favour of the good guy in this situation, and that no particular care was required in most cases in relation to the form of the termination notice. However, the cat has been put well and truly amongst the pigeons by the recent decision of Andrew Baker J, him again, in the Phones for You case. Looking at the basic principles before Phones for You, first of all, it's been very long established that if the good guy terminates, giving a bad reason, an inadequate reason, or even no reason at all, he can justify his termination provided that there was, at the time, a good reason to terminate, even if he didn't know of that reason at the time. So if the innocent party thinks that he has a reason to terminate and terminates, it doesn't matter that the reason that he gives at the time is a bad reason, if in fact there's a good reason, even if he doesn't know of that good reason when he terminates. And secondly, no particular form of communication is required. All that's required is the good guy communicates that he's treating himself as discharged from further performance. That communication has to be clear and unequivocal that he is treating himself as discharged from further performance, but as I say, no particular form of communication is required. And if there has been a repudiatory breach, which also gives rise to a contractual right to terminate, then generally the good guy can exercise both rights together. He's not put to an election. There are limited circumstances where an election may be required, principally, and this flows from the EWCA utilities case that I've noted there, principally where there are clearly inconsistent consequences between a contractual termination and a common law termination. In the EWCA case, if the contract was terminated pursuant to an express contractual clause, Celtec would have retained title to a vast amount of telecommunications equipment. If there was a common law termination, then that equipment, the title to that equipment, would have vested in EWCA. And clearly, therefore, it wasn't possible to terminate both on the contractual ground and on the common law ground because there are plainly inconsistent consequences between the two. And as I say, in practice, those principles have led to a liberal approach in favour of the innocent party. A termination notice citing a contractual right to terminate has usually been construed as also an acceptance of a repudiatory breach, so that the innocent party is able to recover his loss of bargain damages. Reference to an express contractual right to terminate doesn't, or hasn't, generally speaking, led to a loss of the ability to recover loss of bargain damages. And a couple of examples of that in operation: this Deutsche Gdanske case. Buyer renounced 6 shipbuilding contracts, saying it wouldn't perform. In each case, the yard served keel-laying notices, and when the keel-laying instalment wasn't paid, purported to terminate pursuant to an express contractual term. However, in 4 of the cases, it was held that the keel-laying notice was invalid, so the contractual termination was also invalid. But Mr. Justice Thomas held that the notices also accepted the renunciation of the contract because no particular form is required, the party can rely on grounds other than those given at the time, and the notices unequivocally stated that the contracts were at an end. That particular point wasn't pursued on appeal, but there certainly was no suggestion in the Court of Appeal's decision that any criticism could be made of Mr. Justice Thomas's reasoning. And then second example, the Stoichniki-Dinya case, a buyer terminated pursuant to an express term on the yard's failure to deliver. The arbitrator awarded loss of bargain damages. Now, at first instance, Mr. Justice Burton found against the buyer and allowed the yard's appeal. But on appeal to the Court of Appeal, the buyer's appeal was allowed. Now, the ratio was that all the sums which were claimed as damages were recoverable even in the event of a purely contractual termination. In other words, they were recoverable pursuant to the express terms as well as by way of damages. But the Court of Appeal, admittedly briefly and at least arguably obiter, also expressed its view that the notice, although only referring to the express terms of the contract, was quite unequivocal as to Gearbulk's intention to treat the contract as discharged, and that was all that was necessary to enable the notice to be treated as a common law termination as well, and to enable Gearbulk to recover common law damages for loss of bargain. Now, in the Phones for You and EE case, the facts were as follows. Phones for You had appointed administrators, and EE sent a termination notice terminating with immediate effect in accordance with an express clause which gave a right to terminate in circumstances where administrators were appointed. Phones for You sued, claiming unpaid commissions, and EE counterclaimed. And the case before Mr. Justice Andrew Baker was in relation to the counterclaim. It was in two parts. The first was because following the termination, Phones for You had posted a message explaining what had happened and including in the message a sad face emoji. And EE sought to argue that this was a breach of an express term of the contract, providing that Phones for You would not make any misleading misrepresentations.
What was the picture?
Yes. Yes. Now, it is fair to say that the strength of argument on the first limb is probably reflected in the strength of EE's arguments on the second limb as well. But alas, the first limb wasn't argued before Mr. Andrew Justice Baker on this occasion. And so the legal significance of the sad face emoji has not yet been determined by the commercial court. Rather more pertinently, perhaps, EE also counterclaimed for loss of bargain damages. They said that Phones for You were under a key obligation to promote EE's contracts, that Phones for You were in repudiatory breach of that obligation by appointing administrators and therefore no longer trading, and that EE's termination notice was an acceptance of the repudiatory breach as well as being a contractual termination, and they claimed £2 million, which I'm sure in no way, other than coincidence, was the sum necessary to defeat the Phones for You claim for unpaid commissions. 200 million, yes. It's good to have your speech proofread by the chair as you go along.
Well, you haven't got much more time.
So Phones for You sought summary judgment on the counterclaim. They conceded that the key obligation existed, and the judge held that it was arguable that there'd been a breach of it. But he awarded summary judgment, reverse summary judgment, against EE because he held that there'd been no acceptance of the repudiatory breach, which was a necessary element of the claim for loss of bargain damages. I've set out the termination message there. It's in the notes, and you'll see it refers to the express clause. But it also says that nothing in the notice should be construed as a waiver of any rights that EE might have with respect to the agreement. Now, in holding that that wasn't a valid common law termination, and that the right to common law damages for loss of bargain had been lost, Mr. Justice Andrew Baker's reasoning followed three stages. First of all, and apparently uncontroversially, he said, the necessary causation for loss of bargain damages to be recoverable is created by the innocent party choosing to treat itself as discharged from further performance of the bargain and communicating that choice to the guilty party. That communication requires no particular form, but it must be clear and unequivocal. Now that looks pretty orthodox, and one might think that saying the innocent party choosing to treat himself as discharged was within the scope of the termination notice that had been served. However, much more controversially, he then went on to say, the loss of bargain damages claim requires EE to show that the termination of the contract which created the loss of bargain resulted from the repudiatory breach or renunciation by Phones for You. That is presently to be assumed EE might prove at trial. That in turn requires EE to show that the contract was terminated by its exercise of its common law right to terminate for that breach or the renunciation. So in other words, to recover common law damages, you have to show that your termination was caused by the repudiatory breach. Then even more controversially, at the second stage of his analysis, he said, if a termination letter communicates clearly a decision to terminate only under an express contractual right to terminate that has arisen irrespective of any breach, then it cannot be said that the contract was terminated for breach. And so a claim for damages for loss of bargain at common law cannot run, which at first blush seems plainly inconsistent with the earlier shipbuilding cases. He said that the reservation of rights in the termination notice couldn't assist EE because he said that if by the notice they didn't terminate for breach, the reservation of a right couldn't create a right that had not been created by the notice, which at least has an internal logic to it. Now, how did he deal with the authorities? Well, that's the slide. That's well, not at all, alas, but I'm not going to go through in the same level of detail he did. If one Googles an elaborate dance, that is one of the images that appears. And really, that is what the judge had to do. He performed an elaborate dance through the authorities, distinguishing some, holding that the Boston Deep Sea fishing case was a shield and not a sword. He held that some of the decisions that we've looked at were obiter, such as the Court of Appeal decision in Stocznia Gdynia, and he held that other first instance decisions, which really had stood unchallenged for many years, had to be seen as being incorrect and impliedly overruled by a Court of Appeal decision called Leopolis and Lonsdale, an unreported decision on a summary judgment application where none of the relevant authorities had been cited, and on very unusual facts in that case. Now, there's a further wrinkle here, because we can't simply say that, the question is, can we simply say that determination is pursuant to both express terms and for common law repudiatory breach? Unfortunately, that's not a get-out-of-jail-free card, because in a recent decision of Mr. Justice Leggett, he held obiter that if contractual and common law terminations couldn't occur together, so in other words, the Dalkia Utilities type of case, then a notice purporting to exercise both rights would be ineffective to exercise either right. So what's the answer? Well, where there is a contractual right to terminate and a common law right to claim damages, care is certainly needed in every case. And I've set out in the notes some of the considerations that have to be taken into account. But the takeaway message is that where there is both a contractual right to terminate and potentially a claim for loss of bargain damages, considerably more care than before is now going to need to be taken in relation to the drafting of the termination notice. Otherwise, there is a real risk that the loss of bargain damages claim will be lost. Thank you very much.
And so we come to Benjamin Cotter.
Good evening. As you can see, we've run out of Queen's Counsel, and now we're scraping the bottom of the barrel. The idea of the next 15 minutes is... the idea of the next 15 minutes is to tell you a bit about this case, Al-Katir and Jagladki. As you can see, I've adopted a sort of Socratic method of questions and answers in these slides. And the first is, what prompted you to give this talk? Well, having heard Poonam, we know the answer to that. It's firstly because I appeared in it, not on my own. I appeared with Rob Thomas for the good guys, and Tom Macy-Dare appeared for the bad guys, whose solicitors are also in the room, I see. And more importantly than that, because it contains an interesting analysis of the application of forum non-conveniens principles, and in particular, the importance of the place in a tortious case, of the place where the tort occurs. Just briefly start with the facts of the case. It was a collision between the Jagladki, an Indian VLCC, and the Al-Katir, a Qatari-owned LNG carrier. And the collision took place in the port of Fujairah, so within Fujairah territorial waters. The Al-Katir interests managed to arrest a sister ship in Milford Haven, and that allowed them to serve in rem proceedings in English Admiralty Court. The Jagladki interests applied for a stay of proceedings in favour of Fujairah. And in the course of the stay application, the Jagladki interests accepted that they were 100% to blame for the collision, so the dispute was just about the quantum of the claim. And Mr. Justice Bryan declined to grant a stay. He declined the Jagladki application, and he held that Fujairah was not a distinctly more appropriate forum for determination of those quantum issues. I'll just start with a very brief overview of the relevant test. I'm sure you all know this already. It's really for Lord Clark's benefit, mostly. The leading case is Spiliada. The test is that the court should grant a stay where there's another available jurisdiction, which is a clearly more appropriate forum. The appropriate forum is where the case may be tried most suitably for the interests of all the parties and the ends of justice, and where you can establish jurisdiction as of right. There's a two-stage inquiry. First, the appellant has to show that there's a distinctly more appropriate forum, and then the respondent can show that justice requires that a stay be refused for some other reason. How do those principles apply in collision cases? Well, the case law distinguishes quite dramatically between two different factual situations. For collisions in international waters on the high seas, there is usually no natural forum, and that was recognised in Spiliada itself by Lord Gough. But collisions in territorial waters are treated differently, and in fact, before Spiliada, two of the cases that had laid the groundwork for that decision were cases concerning collisions in territorial waters, the Atlantic Star and the Aberdeen Dava, and stays were granted in both cases. And since then, there have been a long line of first instance judgments where stays are granted in territorial collisions. There's only one English case that I've been able to find where a stay was refused. That was a case called the Poe, a decision of Mr. Justice Sheen at first instance, which then went on appeal. And I think it's fair to say that there were some raised eyebrows about the decision in the Court of Appeal, although it was eventually upheld on the basis that only one of the judges thought that it was plainly wrong. The other two indicated they might have reached a different view themselves, but that wasn't enough for the appeal to succeed. But why is it that stays are often granted in territorial collision cases? Well, the answer is that these cases engage a principle known as the Alberforth principle. And that's named after a decision of the Court of Appeal. And the principle is summed up by these two quotations. Lord Justice Ackner said, the jurisdiction in which a tort has been committed is prima facie the natural forum for the determination of the dispute. And Lord Justice Robert Gough said, if the substance of an alleged tort is committed within a certain jurisdiction, it's not easy to imagine what other facts could displace the conclusion that the courts of that jurisdiction are the natural forum. But why? Why should it matter where the tort was committed? Well, that's a good question. And we're getting into more controversial territory now. In the Alberforth, both of the judges giving leading judgments quoted this dictum of Lord Pearson in a case called Distillers. Lord Pearson said, it is manifestly just and reasonable that a defendant should have to answer for his wrongdoing in the country where he did the wrong. And that dictum from Distillers has been understood as the rationale of the Alberforth principle in a number of subsequent cases, including by Lord Steyn in Berezovsky and Michaels in the House of Lords. So the suggestion seems to be that the location of the tort is an inherent connecting factor with that forum, that there is an inherent justice in holding the defendant liable in the place where the tort took place. And the Alberforth principle has been applied in a number of the collision cases involving territorial collisions. I've put 3 of them up there that are particularly notable for the quality of the judge deciding them. In the 3rd of them, Caltex, it's a case where, like the Alcatea and the Jagladki, liability was not an issue, and the only issue was quantum. And Mr. Justice Clark, as he then was, declined to distinguish the Alberforth on that basis. He said it applies equally, even where liability is admitted and quantum is the only issue. Now, a few words on the limits of the Alberforth principle. It's clear that it doesn't create any sort of presumption that the place of the tort is a natural forum. Instead, it's described as a weighty factor or a strong factor in favour of that forum. And I put up there two quotations, one by Lord Steyne and one from Lord Clark. So with that background, let's see how the judge approached our case. Now, I'm going to try to present this neutrally as far as I can, but I'm sure Reed Smith will shout if I'm struggling to do that. Mr. Justice Bryan took a slightly different approach. He held that the location of the tort is not a relevant factor per se in itself. It's only relevant insofar as it gives rise to other connecting factors. And of course, in a collision case, the place of the collision will often give rise to other factors. For example, the applicable law, or the place where the witnesses are located, or you might have a marine accident investigation in that jurisdiction. But the judge doesn't seem to have understood the Alberforth principle as reflecting any kind of inherent justice in holding the defendant liable in the place where the tort occurred. So that's quite different from the distiller's rationale. And in reaching that conclusion, Mr. Justice Bryan was quite heavily influenced by this quotation from the judgment of Lord Mance in VCB. And Lord Mance was in the majority. Lord Mance, I won't read it out, but Lord Mance makes the point, which is not controversial, that the place of the tort is always one of a number of factors, and that at the end of the day, ultimately, it's a weighing of the discretion, and that no one factor can be definitive. But I just highlighted those words in red because one might wonder whether, if the analysis is that even viewed by itself and in isolation, the place of the commission establishes a prima facie basis for treating that place as the appropriate jurisdiction. It's difficult to see how the Bryan analysis is consistent with that. So I put it no higher than that. Is there any other support for the judge's approach? Well, there's a decision of the Hong Kong Court of Appeal called the Pen Yang, where the Court of Appeal in Hong Kong said, in some cases, the place of the commission of the tort may be decisive. In others, perhaps not weighty at all. Mr. Justice Bryan relied on that as supporting his view that Lord Mance had changed the law in VCB. But as I put up there on the slide, I do just wonder whether that is consistent with the two dicta that I showed you earlier, where it's described, the place of the tort is described as a weighty factor or a strong or weighty factor. In the Pen Yang, the suggestion that it might never be a weighty factor, or in some cases it might not be weighty at all, is difficult to reconcile with those. So what was the outcome on the application in our case? Well, Mr. Justice Bryan held that the location of the tort didn't give rise to any significant connecting factors. There was no significant difference, he held, between UAE law and English law, and the witnesses and the parties were sort of dissipated all over the world. On the other hand, he held that there were connecting factors with England. In particular, lots of the evidence was in English, so that's a connection with the English language. And also, the judge took into account the fact that English P&I clubs were involved and English solicitors and counsel were involved. And again, because I'm trying to be neutral, I won't say anything about that. But on that basis, he declined to grant a stay. So, what are the lessons that we can learn from that judgment before we send you off to have drinks? Well, VTB on Miss Justice Bryan's analysis is to be understood as, I think, diluting the strength of the Alberforth principle quite considerably. It isn't, if Miss Justice Bryan is right, always a strong or weighty factor. In some cases, it might be a factor that has no weight at all. And there's also a change in the underlying rationale of the Alberforth principle. There's a sort of movement away from seeing it as reflecting an inherent justice in finding the defendant liable, or holding the defendant liable in the place where the tort takes place, and towards seeing it as just a reflection of the fact that where you have a tort occurring in a particular jurisdiction, you're likely to have other connecting factors to that jurisdiction. And more generally, you might say, well, the judgment emphasises factors to do with sort of practical convenience factors, such as, for example, the language of the evidence, over what you might call inherent or principled connecting factors, such as the justice in holding a defendant liable in a particular place. So it's a really sort of focuses on the practicality of what the proceedings are going to look like. I've also put up there, perhaps a bit facetiously, appoint English solicitors and counsel if you're attempting to resist a stay of English proceedings. I think appointing English solicitors and counsel is a very good lesson for all of our clients to learn in any case, and probably quite a good point for us to go and have drinks on.
Well, thank you very much. Of course, I remain of the view that my dissent was correct in VTB, and well, we'll see in the future what happens next. The trouble with forum non-convenience cases is that they're a farce. Because they're a farce because all the points being relied upon are not the points that the parties are really interested in. All the points the parties are really interested in is in which jurisdiction am I more likely to win. That's the question they're interested in, which has got nothing whatever to do with where the witnesses are, what language is, or more or less anything except that. But that's not quite the way the courts look at it. But I think we should give the combatants, if that's the question, if that's the right expression, a further round of applause, because they must have worked extremely hard at all this. Thank you very, very much.